Thank you for joining us for this episode of Comply on the Fly with M3 and Karen B. Comply on the Fly is your trusted weekly resource for reliable insight and quick answers on common employee benefits compliance questions. Please note, this podcast and the contents herein do not constitute legal advice. Seek the advice of counsel for any employee benefits compliance-related guidance or strategy.
Hello, everyone. I'm Karen B. And the Comply on the Fly question of the week is, what did the Department of Labor, or DOL, recently say about FMLA and remote workers? Very timely question, because on February 9th, 2023, the Department of Labor, DOL, Wage and Hour Division of the DOL, WHD, issued Field Assistance Bulletin 2023-1. The bulletin addresses the application of family and medical leave, or FMLA, eligibility requirements to remote employees. It really didn't give us anything new, but rather reaffirmed that the general eligibility rules are applicable to remote workers. Specifically, current FMLA rules state that an employee is eligible to use FMLA leave if the following conditions are met. The employee has worked for the employer for at least 12 months. The employee has at least 1,250 hours of service for the employer during the 12-month period preceding the need for FMLA leave. And the employee works at a location where the employer has at least 50 employees within a 75-mile radius. Now let's look at two of these required eligibility provisions. First of all, as it relates to a remote worker, hours of service. The DOL guidance states that employees who work remotely are eligible for FMLA leave on the same basis as employees who report to any other worksite to perform their job. The employer is required to keep accurate records of a remote employee's compensable hours for FMLA eligibility purposes. So here the point is, you got to keep good records of hours of service for those remote employees in order to determine eligibility for FMLA. Secondly, the whole worksite issue. For remote or telework employees, the employee's personal residence is not considered a worksite for federal FMLA. Rather, the worksite for FMLA purposes is the office to which the employee reports or from which their assignments are made. If 50 employees are employed within 75 miles from the location to which the employee reports, the employee would meet the FMLA eligibility requirement. In addition, that 50 employee threshold is determined by counting all employees whose worksite is in that area, including employees who work remotely. So those two things are very important to keep in mind when you are determining FMLA eligibility for remote employees. And also remember that any state leave requirements may apply to remote employees. And that is your Comply on the Fly question of the week. Thanks for tuning in.
What's on your mind? If you have a pressing compliance question, send it to askkarenb@m3ins.com. We'll do our best to cover it in an upcoming episode. You can now follow and subscribe to Comply on the Fly on Spotify, iTunes, and Google Podcasts. Make sure to tune in next week and encourage others to join us.